and welcome to this week's Ask an Atheist. My name's Liz Cavell. I'm Associate Counsel for the Freedom from Religion Foundation. I am joined in our studio today by FFRF Senior Counsel Patrick Elliott, alive in the flesh in Madison. And we're bringing you this special episode of Ask an Atheist, a different day and time today, because we're discussing a Supreme Court opinion that just came down this morning, and that's in the case of Groff versus DeJoy. It involves religion in the workplace. We're going to give you the breaking news of what's at stake, how the court decided it, and the real-world impacts that we're expecting to follow. As always, if you have questions about our topic today, drop them in the comments below or send an email to askanatheist@ffrf.org. So the Groff v. DeJoy case, it was handed down this morning. It was a unanimous opinion. Don't see those very often. Kind of an odd one. We're going to break it down in a minute. And this is really fun. I was just saying this is like total improv because this is live. You are witnessing Patrick and I's first conversation about this opinion. It just came out at 9 a.m. Central. So we've all been sort of processing it, catching up with what it said. You and I, Pat, did an episode back in April when they had oral arguments in this case. So before we jump into what the court ruled today, just give a little quick refresher for viewers. What was this case about?
Yeah, and I had to refresh myself because it's been a while. I mean, this was argued recently, but it seems like it's been forever. We've been waiting for these decisions. So today there was a decision. We're maybe getting a decision in another important case tomorrow. So it's kind of all needed a little bit of a refresher. So this is the case about the Postal Service worker who wanted to take Sundays off. And the Postal Service said that they could not accommodate his requests. And kind of how that played out over time was he was hired as a rural postal care associate. And they basically fill in for when other employees can't be there. And so he would work, holidays at other periods in time, and became a problem that he couldn't work Sundays when Amazon contracts started to come up with the Postal Service. So at first he could be accommodated, but it became an increasing problem because this was a small Pennsylvania regional office where if he wasn't there, if he wasn't able to fill in, the postmaster themselves would have to fill in, or some other employee would have to be taken off from a Sunday that they would want off. So so somebody filed a union grievance over this. Somebody apparently, I think, tried to transfer out of this office. It became a problem, and he ended up being terminated after progressive discipline. He sues and brings a Title VII case, so this is like an employment discrimination case, saying that the Postal Service should have accommodated his request to have these Sundays off. And in response, the Postal Service says, we didn't have to do that because it would have posed an undue hardship on how we operate. That case then makes its way through the lower courts, and the District Court and the Third Circuit Court of Appeals rule in favor of the Post Office, saying, yes, this was an undue hardship in the Postal Service. Supreme Court takes the case, and that's where we became worried, Liz, right? We're saying, what's going to happen with the court in this case? So that's kind of the procedural history, the factual setup, and kind of surprising, unanimous opinion today.
Yeah. So I'm going to correct you real quick because Groff didn't quit or didn't get fired. He quit after progressive discipline because we already know he doesn't need any help being martyred from us. So that's what happened. But there's no dispute that his failure to accommodate his religious request was the reason why he left his position. And so you mentioned Title VII is the legal framework at issue. And that's really important because this is a case that involves just interpreting the words in a statute. So this doesn't involve a constitutional claim. This is not a First Amendment case. It's about the rights laid out by Congress in Title VII to the Civil Rights Act. So it involves a case that interpreted this part of Title VII way back in the 70s. So it's an almost 50-year-old Supreme Court case that interpreted what undue hardship to the conduct of business means when courts are weighing whether or not an employer can be relieved of its obligation to provide a religious accommodation. So that case is called Hardison, and it gave some language called more than de minimis burden or more than de minimis cost when it was analyzing what undue hardship meant. And that was, sort of criticized much over the decades, but was sort of interpreted in a way that did give fairly expansive religious accommodations to employees. So the Groff and the religious right conservative legal law firms that represent him were asking the Supreme Court to overturn that case and to adopt a new, really much broader definition of the rights under Title VII that are required and what employers have to do when faced with this kind of
right. And this
crisis.
is why we were worried, because this is a group that we do, is on the opposite sides of cases as us. First Liberty Institute is representing him in this case. They're seeking to really expand what the benefits to religious workers would get. It basically would amount to preference. It would say, if you have a religious reason to get out of a workplace rule, the workplace is going to have a really high standard in order to defend themselves and not giving it to you. The amicus briefs on the other side are all arguing this too, right? This is not just the kind of lowly postal carrier versus the big bad post office. I mean, there's an effort and a movement behind increasing the rights of religious workers versus the rest of us. And I think that's the concern is, and just as how society operates, for things like days off, the weekend is a time where people do stuff. It's leisure time where students are home, people do leisure activities. And so even as atheists, I think we'd be bothered to say, we all have to work, you have to fill in because your coworker is not going to work on Sunday, right? So I think that was a little bit of the backdrop of the concern from the atheist side is wait a minute, we're going to be kind of second-class workers if every religious worker accommodation now gets this super high standard. So I mean, we can talk about, you had authored an amicus brief in this case on behalf of FFRF, so I don't know if you want to share a little what we talked about.
So that's a good segue into bringing up this other important issue that was kind of forward in the case and what we really focused on in our amicus brief, which is one of the things that the plaintiff Groff and his allies were arguing or asking the court to rule, one of the actual questions presented in this case, they wanted the court to say that when analyzing these Title VII religious accommodation cases, burdens on other employees, burdens on coworkers, third parties, alone cannot establish an undue hardship. And that was something that we thought was really vital to push back against. That's what we focused our brief on. And that's what you're talking about here, which is how can you separate out the harm and the burdens on coworkers from things that affect the conduct of an employer's business, right? And we can kind of jump in and talk about how the court dealt with that. So obviously this was a unanimous opinion, which is rare for this court. And so right away that signaled to me this morning, okay, this is probably a narrower opinion than what we could have feared for the worst case scenario. But it was written by Justice Alito, which sends my brain in the opposite direction. So what happened here, and another thing to consider is that I'm really glad we're talking about this live today because it's the end of the term. The Supreme Court has a lot of controversial cases to hand down, and they handed down their big affirmative action cases this morning as well. And so it's kind of getting swallowed up in some of the competing coverage, rightfully so, of the affirmative action cases that were not so favorable this morning. But I did want to seize the opportunity to push back on some of the religious outlets, the religious media outlets, right? The Catholic News Agency and the Adventist, news outlet. These headlines that are basically Christian mail carrier wins the day, unanimous court sides with religious protections for workers. And I think the actual opinion was a lot more nuanced and less dramatic than that, as signaled by the unanimity. So, so let's get into it. So, first off, the court was asked to overrule Hardison. Did it do that? No, it did not. The court was asked to adopt a new test to supplant the de minimis test that had been used over the years, and it did not do that either. And then finally, it was asked to make this finding that burdens on coworkers could never be sufficient to prove or to show undue hardship on the conduct of business, and it didn't do that either. So those are three good points.
So they shouldn't be high-fiving. I mean, it's basically
right.
I get the the spin aspect. So this is for all of our viewers and for the public. Sides may claim victory here, even though if you just read the part that said reversed and remanded, so this case is going to go back to the lower court. That sounds good,
right.
But the fact that they got none of the things that they wanted is not a good sign for the religious side. And I think our side could say, bullet dodged here, I think, is that this is a narrow decision. The fact that it's unanimous, which again we don't see very often, and then we can get into some of the nuance of what the court said. And it's actually short for Supreme Court
right.
opinions. I was worried, am I going to have enough time to read this today as I'm driving from Minnesota to Madison? But it's total with the total opinion and concurrence. It's like 29 pages or something. So
right.
that's short for what the court, and a lot of it's just background, explanatory stuff. Background. This could have been
right.
Even shorter. So I don't know if you want to explain more about how all of them agree on the points. I think, and there wasn't a dissent, which is also, I guess not a dissent, but the concurring opinion isn't really undercutting much, I think, in right. the majority. So
here's what the court did decide. So what commanded the unanimous support of the court here? And this is one where it's as a lawyer, I kind of hated this opinion because it was why is the Supreme Court taking a case to do this?
Right,
but
right.
Okay, they took this case and here's what they did. They took the opportunity to clarify what lower courts should do when they're giving meaning to the undue hardship standard language that is found in Title VII. And they basically are repudiating that more than de minimis language from the Hardison case, saying that Hardison used that language that was seized upon by lower courts over the years, and sometimes it might have ended up, offering too narrow of protections than what was envisioned by Title VII. And so we are kind of repudiating the idea that the de minimis test is the rule that was decided in Hardison, but not overruling Hardison, because basically the court is citing that Hardison case and all of the other ways in which it analyzed and described undue hardship to really make the point that de minimis is not the test. So the case law, that 50 years of case law that has developed over the course of, from the 70s until now is still good law, but the court is clarifying, as they, put it many times, that something more than just a de minimis cost has to be proven by an employer before they can defend not giving a religious accommodation to an employee. So, and I think they also pointed out that in the Hardison case, that involved an accommodation that would undermine the seniority rights, collectively bargained for seniority rights of coworkers. So on the one hand, they're sort of putting that into context and saying that involved something very specific that was in and of itself more than a de minimis burden. But I thought it was noteworthy because it's acknowledging that that analysis involves some sort of analysis of burdens on coworkers.
Right.
So,
and that's where Justice Sotomayor, who wrote the concurrence, it says that point, which I really felt, it reminded me of your brief and there were other briefs recognizing this too, is saying, burdens on coworkers are burdens on how business operates, right? If you have bad morale and if people leave, if you can't get people to cover shifts, then that means you have to close, or you can't, fulfill your contract here. They have to fulfill a contract with Amazon to deliver packages on certain days, or probably other carriers now. In this case, goes back a number of years, but it's just so obvious, and that's what's funny is that we had to explain that and other people had to explain that. And then in the concurrence, Justice Sotomayor is saying, yes, burdens on coworkers still matter if they ultimately impact, how the business operates. And so I think that saves much of what we were worried about, right? We were worried about, one of the examples that we kind of gave, and we gave examples of accommodations that people might ask in the workplace that would be problematic. So the Billy Graham rule, somebody who works in a workplace and is a man and says, I cannot be alone with anybody who's not a woman who's not my wife. It's well, if you're one person, two people on night shift, like obviously the business can't accommodate you, right? Like this is a problem on the business to like completely hire more people.
Right.
So those were the types of examples I think we tried to, again, I don't know that they impacted the court at all, but thinking through like what are the types of religious accommodations that somebody might ask for. It could be anything, literally, it can be anything,
Right. Right.
as long as they have a religious belief related to that, and that impacts how it operates. So I think that seems to be saved, right? I mean, that's how I read. We're still digesting this. This is just a few hours old, but it seems to be saved.
And so I think part of what was good, I mean, we can talk about the bad, which is the fact that Alito drafted it. It definitely contained a lot of that disdain for, like, neutrality between religious and non-religious workers that just, like, drips from everything Justice Alito says or writes. But you can also kind of feel that, like, obviously he got unanimous votes for this, so there's some restraint there in terms of how far he might have gone in some of the in some of those sections. So, for example, we talked about this in the episode we did on oral arguments. He really wanted to make the point that the Establishment Clause concerns, like, dominated the day when Hardison was decided. Never mind the fact that, like, nothing about that is in the Hardison opinion. Like, the court was not preoccupied with whether or not, so the question would be, like, if Title VII means you have to give religious accommodations to religious people, and that's not fair to non-religious people or people of a different religion, does that law, that requirement of Title VII, actually violate the Establishment Clause? And Justice Alito likes to take every opportunity to remind the country that the Establishment Clause, thanks to this current court, is no longer that robust that you could even contemplate that that would be a problem. So he wants out that. That's a reason why we might see this confusion under Hardison and Title VII from the 70s to now.
I got that too. And it shows how far we've come, from us who are, I guess, we've been doing this for 12, 13 years to, the founders of FFRF and Dan and Annie Laurie, the current co-presidents, like how things are different. Because in 1977, it's like, wait, we have to be worried about giving special rights to certain Americans because of their religion. And in the opinion today, he's kind of rebutting all of that as like, that was mistaken. And then also pointing out like, and we've overruled the Establishment Clause primary test that we've used. They say that Lemon versus Kurtzman has been overruled, or the Lemon test. So that had nothing to do with this case. So I picked up on that as well. And I like that we're doing this blind in the sense like we literally haven't talked about this until this moment. And I'm like picking out of 29 pages, I'm picking out on these two sentences too. And I'm like, wait, this is why is he talking about this? That was like,
that's the page where you're like, he's deliberately trolling us. Because it's like, again, has no relevance to this case. It had no relevance to the Hardison opinion, but he just wants to point out like some scholars and me imagined that it played a behind the scenes role and now it doesn't factor at all. So we need to know that the context has changed in terms of what the potential reasons would be that courts would be doing certain things. But I think one thing that was like really important in this case, you mentioned how short it was considering how long these cases usually are. And I think that's a really good thing in that like they really didn't, when we were predicting how this case might come out, I think the narrowest kind of best case scenario given the court that we have was something like this, which is they repudiated the de minimis test, which we knew everybody was unhappy with, including some of our, usual progressive allies. And then didn't say much else, kind of left the rest to be worked out in the lower courts. And I think that's why it's important to tack on. Yes, this case was, like the Third Circuit opinion was vacated and overturned in that sense, but it's being sent back down to be heard now anew in light of these clarifications. And it explicitly, Alito says in the opinion, the Postal Service may or may not prevail, but you need to rehear the case given all of this clarification that we've given you on the framework. And so they didn't say anything beyond what they wanted to say about the de minimis standard. They were silent as to a new test, how a new test would work itself out in any given situation. All they really did was say that de minimis, that language and that framework doesn't do enough to give meaning to the plain language of Title VII. And they didn't say, they did say that burdens on coworkers and those types of things can be part of the analysis when it is also, when the showing is being made that it affects the conduct of the business. So those were the
right, and things that wouldn't qualify, which we actually agreed with, would be a coworker not liking that somebody gets an accommodation, like particularly for like a dress code arrangement because they need to wear a headscarf.
Right.
Like just because a coworker is upset, that cannot then lead to a burden or an undue hardship on the business. So we what's funny is like how much agreement there was here, because they say the Solicitor General had argued this case for the post office, and like I think they basically are getting most of what they had said and not what the worker had said. But the court can't come out and say, like, we completely agree with the Solicitor General. And I think they in fact say, the Solicitor General points us to looking at like prior guidance that the EEOC provides guidance to like employers and also makes rulings on these cases, sometimes takes cases on behalf of workers for religious accommodations. And the court says, yeah, a lot of their guidance is good, but they don't like, so that's also helpful, but they wouldn't go the full way. It's like, yeah, the EEOC gets it right. We're not going to overturn what they're doing. So it was kind of like a pat on the back there for the EEOC, which is good for our side, because we think how accommodations have been working in practice is like worked. We're fearful of like, don't throw this out. And I actually got a text message from an attorney today saying, who represents sometimes employers, are just like worried about the case, and I haven't had a chance to even respond to be like, I think things are okay, from the employer standpoint.
Right. I do think it was very annoying. See, like this is the Alito of it all. The part where it's like, did words really have to be spilled over the fact that like people that are like have animus towards specific religions, that's not a consideration in the undue hard, like the section you just pointed out. It's like, that's where like the fact that Alito's writing the opinion is like, that had to get airtime. And of course, like all the other justices are like, yeah, sure, we agree with that, but nobody's arguing that. But okay, that's where it's like, it did have the tone, like not to paint too rosy a picture of it, because like it does have the tone of like, this is so important that we protect religious rights, and it's it's really paramount, and there's all this hostility towards religious workers, and also him bringing in all of the amicus support that they had, that Groff side had from minority religions. He said that in oral arguments too, to kind of back him up in how much hostility there is towards religious workers. And I think a lot of that imagined persecution is what motivates this court and justifies this court in how much it privileges religion in all of its other cases. And so I hated to see that, and I think that is still a bad kind of a step down that road that I think is really harmful. And so I'm not like jumping for joy, but I do think that this opinion was as narrow as we could have hoped, considering the history of this Title VII statutory interpretation and the court that we have. So
yeah, and I think, you're not just making this up, because we have opinions when you read what the justices say. You're like, oh, and we listen to the arguments, and you're like, oh, this guy's really has it out for the non-religious. Like anyone else can listen to Alito's speech in Rome last year, or was it actually at the Vatican? Or he was very much against, like, we live kind of in this, it was like the Catholic group against the secular world.
Yeah.
And it stuck with me, and I'm probably going to misquote what happened, but I recall him saying something like he was visiting a historic church in Rome, or what you do, and saw a little boy, and looks up at like the crucifix and is like, who is that? To his mom. And like to Alito, that was like the worst thing that could happen. It's like, this is what children do, first of all. It's like, it doesn't tell you that this kid is some like avowed atheist and he just has never seen a crucifix before, but it's like a childlike question. Also,
he must be being raised in America where the secular world is.
But even if this was a non-Christian family, that's not an insult to you. Like it's okay that people have a different belief of what this figure is, or so it just was like, it stuck with me that his story, like he's telling it to like a Catholic audience and is like, aha, like this is the world we live in, and it stuck with me. I think there was a lot of anger in that speech and in the questioning in this case and the other religious cases. So that's where
For sure.
just for people who are listening or watching, it's like that's kind of where this backtrack comes from. It's been case after case, the questioning, the opinions, and then speeches that we get hints of like, oh, this is the perspective that this person has, and really has some dislike, I think, for the non-religious that exist out there, and like
for sure
wants to kind of get some of those jabs in the opinion. So I agree with you on it, but I there's a larger story, I think, with some of the justices there.
Oh, for sure. There is. It's just this broader, and right, like this is not like me saying this in a vacuum just based on the Groff opinion. This is the whole body of law that's being decided, especially in the religion cases that we are so keyed into. And it's not just Justice Alito. There's pretty much the conservative majority on this current court. There's this ideology that the neutrality amongst religion that we view as demanded by our secular constitution is like equals hostility towards religion and religious people, and that's just not so. And that's really the kind of ideology that motivates a lot of his opinions and a lot of the conservative majority opinions. And that definitely wasn't absent from this opinion, but I do think it was written narrowly enough to get sign-on from all the justices, which means it was as narrow as it could have been, which is decent. I think since it's half on this and to guide our discussion, and we have a couple here, so here we go. So, sorry. Okay, do you think this means that every religious case in the Supreme Court will be ruled in favor of the religious side? So there's two ways of seeing that question, which is every religious workplace case or just every religious case. So I kind of already just touched on this, which is like, I think we at FFRF are were before today and are still after this opinion, like extremely alarmed at this court's like relentless project to privilege religion and religious litigants under the law. But I don't think this opinion does much to make that worse.
Right. I think that if they take a case, there are 4 justices that want to rule for the religious side. Like that's what we've seen in recent years. Like, find me a case where the religious side didn't do very well before the Supreme Court. However, here I actually think them clarifying the de minimis thing is an actual change to like the law. But if you look, I don't think courts were getting this wrong very much. Like I think a lot of the cases where employers were winning against accommodations, there was actually like substantial costs. Like I don't think there was like a tiny excuse for why they didn't have to accommodate. So in that sense, the fact that the court took this case, like this year maybe they took 60 cases, this is one they took. One of the cases they're going to roll on tomorrow is another religious, or presumably tomorrow is another religious case about whether, a website designer can turn down a same-sex couple who might want a wedding website. This is all in theory because this actually hasn't happened, but she's suing to block the Colorado Anti-Discrimination Act from being applied to her website design services. So that case is like, why did the court take it? Like they want to rule in this favor because this isn't really a need to clarify that today without an actual dispute. So I long answer, but I think, the court wants to rule in favor of religious people. That's why they're taking these. They take 60 cases, and it's like ignoring the importance of everybody else's like disputes over everything.
Yeah.
Like
60 cases out of thousands, because they want to speak on these issues. So here, the fact that having taken this case, this was as little as they said, this was as narrow as it was, I think is a relief. Okay, so I have another question here. Where can the line be drawn? If this man can take off work Sundays because of his beliefs, can I sue because I believe sleeping in on Mondays will make me more productive the rest of the week? So I like where your head's at, but here's where it is just absurd to say that like religion is not privileged in this under Title VII. I mean, that is what Alito was kind of hammering at. Like anyone who thought that there's a problem that Title VII gives special privileges to religious workers, like you're wrong because the Establishment Clause doesn't matter in this context. I mean, he's right in a sense that Title VII, and particularly like the way courts have treated it, is just a special thing for religious workers, people whose religious beliefs or observances require them to do something that would otherwise break the rules of their employment. And that could be wearing religious garb that violates, your kind of dress code, workplace dress code, or scheduling issues that require, that have to do with Sabbath observance, that kind of thing. So it's not something that like readily applies to atheist and non-religious employees. And that's a problem, that's an unfairness just kind of built into the statute. Like it requires religious accommodations.
Yeah, and so I guess you have to have a sincerely held religious belief. So if you just want to sleep in on Mondays because it's going to like make you refresh for work, that's not a sincerely held religious belief. And also the court is probably going to be skeptical if we like invent really cool new religions that allow us to do, that kind of thing. But I think the point you're getting at with dress is like, this is how I've always conceptualized this, is like somebody's a burden on, somebody's religious practice that requires them to do something is much more likely to be accommodated, which is to say like, I need to fast, or I need to take a specific prayer break, and I need to wear religious garb. Like, you're putting a burden on you. I think when it comes to time off, then we start to get into the zone of like, are you like making somebody else like help you do the religion in a way that actually like causes a problem for them? They have to cover all of your shifts. So that's where, and I think this is where this case goes to, is like the courts are going to be so in the facts and context specific about like, is the particular thing the person's asking for that big of a problem? Because sometimes at places like, particularly places that have large amount of Muslim workers, the factories, or there's like a lot of these meat processing plants have to do this, and they say, okay, we're going to figure out break schedules so that people can, do a prayer break during the day, and like that's probably not that big of a problem. It's a bigger deal when you're just like, hey, I get all Sundays off forever. It's awesome. Like, even if other people have to work Sundays. So, yeah, you have to have a religious belief in order for it to fit. An accommodation.
And then we're talking about, these are the most typical ways in which these issues have arisen, right? Like, we're categorizing this broadly, like into garb and prayer breaks and Sabbath observance, so schedules. But there's kind of this whole world of behaviors that are kind of like a dark cloud looming over the whole thing, and that have presented themselves in Title VII cases that were really concerning if the court would have blown a big old wide hole into Title VII and really broadened what employers have to do. And that involves like proselytizing behavior, or behavior that involves like harassing other employees, or, for example, examples from our brief included like employees that like think all LGBT employees are going to hell, and so it's part of their like sincerely held religious belief and practice to like tell them that and write them individual letters telling them, trying to save them and telling them all about how they're going to hell. Like, that's super distressing for other employees. It's happening at work. It might not have like a quantifiable effect on the conduct of the business, but what Groff and his backers were trying to get the court to say is a situation like that could never, without dollars and cents, rise to the level of an undue hardship. And I think it's important to note that, like, we avoided that outcome in the decision that came down today, because like these are the types of cases that are gonna present themselves as the, aggressive religious right forces are continuing to push and push and push these cases, these workplace cases that don't just involve scheduling and private religious observances, but they involve like foisting your beliefs onto other employees, or even denying service to certain customers and patrons based on your religious beliefs. This is the stuff that's happening throughout the country, and these cases are currently, wending their way through the courts. And what happened in this case could have had a bigger impact, I think, on some of those cases. It remains to be seen how courts are going to analyze them under this clarification opinion today, but I think it could have been a lot worse in terms of giving space for some of those cases to succeed.
Yeah, and the thing we don't have an answer to is how will lower courts, there's a lot of Trump appointees on lower courts.
Right.
Will this be a little more of an opening to say, look, you're Walmart, you're big. You can pay a lot of money to this employee to be off or to pay overtime or to do whatever. Like for some employers, there might be a little more fear on the line because of their size, because the language the court's using is like substantial costs. So substantial costs for a smaller employer, may not be a large dollar amount, but for a larger employer can be a problem. So I think the thing I fear is what will the religious right do with this? Will they start picking out other cases and go to the courts that have Trump-appointed judges to try to move the law a little? But I don't think this really equips them with that, but it could be an opening.
Yeah.
It could be a small opening for that.
I think that's right. I mean, it's without a doubt, the clarification today was that the test for what constitutes an undue hardship on the employer is a little bit more than what we said it was, or what the court said it was in the 70s. And so that is an opening to further privilege religious workers to the detriment of, the rest of us in the workplace. And that's not great. It's a move in that direction, which is, I think, harmful to more workers than are going to be helped by today's opinion. So I think it's right to be concerned for how this opening pushes the law in a direction that we really don't want to see it go in. But I do think there was a maximalist version of this case, especially given the court makeup, that was, I think, dodged. I'm not handing out any profiles in democracy awards to the court, but I do think it is worth sort of pushing back on the narrative that Groff wins, court sides with, Christian religious worker for expanding religion in the workplace. I think, there's an element of that, but this was pretty narrow.
Yeah.
All right, let's see. Any more questions? What does this decision imply for the future? Is there any way this can be seen as a good thing for non-believers? What do you think about that?
I think it is that. So sometimes when the court takes an opinion like this or takes a decision like this, it might be a while before they revisit it. So we may have to keep, hold the line here on what the status is for employers and employees. Non-religious workers, I think it's pretty good. I think we would tell, FFRF's not shy when we're upset about an opinion. So you'd be getting it hey, this could be a really big problem, right? We're going to let you know. But I think it's pretty good for non-religious workers in the sense it wasn't an earthquake to the employer scheme. The piece we don't know, and maybe this is just larger society-wise, as non-religious people grow, there's a more aggressive pushback from religious people in this country. I mean, this is my observation. I don't know, with the younger generation being more non-religious, are we going to have more workplace disputes over religion? You had referenced kind of aggressive proselytizing, denigrating LGBTQ coworkers. I don't think this gives a green...
Misgendering people.
Yes.
This is what I'm really concerned about, and what FFRF is concerned about, and where this is, we're not jumping for joy at this case, because it leaves for another day and nudges in the direction of a higher burden for employers to disallow a situation where the workplace is a school and the employee is a teacher that needs the religious accommodation to misgender all of his trans students. That's a real case that exists right now in multiple jurisdictions. And so does this little nudge in from de minimis, all that school would have to show is that accommodating that religious need would constitute more than a de minimis cost or hardship on the conduct of its business. Its business being the education and, pedagogy.
You're right, though, that maybe the concern is, and this could be a concern for non-religious workers, is translating everything to dollars and cents sometimes is difficult to do, especially in the context of a school's mission isn't to make the most dollars, unless it's a private, for-profit institution. It's to impart an education on students, and that's disrupted if the teachers can do whatever. So thankfully, that court, the case you're talking about, the court had ruled correctly so far.
Right.
I don't think it will be. I'm hoping it won't be disturbed, but these are pending in other. In other places.
And that's where, that is what, those types of cases are what the plaintiffs' backers have their eye on when they're asking the court for what they're asking for. They're saying, court, please rule that, without dollars and cents, you can't make this showing, because harm to third parties is the main thing affecting the conduct of the business in the school example, right? We're not talking about dollars and cents. We're talking about burdens on the essential functions of a business. If the business is a school or the business is a hospital, not providing people with health care based on your religious beliefs, maybe it's not, it's not quantifiable, but it is really, it does have a really big impact on the conduct of your business. So does this, give that much more rope to the forces behind Groff that are taking this case? It's not as much as they wanted, and when they are asking for these things, these are exactly the types of cases that they're looking to push forward. So that's bad, and it's alarming, and that's what we have our eye on, because that's where there's real harm to be done. And of course, that's what the religious right is seized on at the moment, which is anti-LGBTQ backlash and anti-reproductive access work. So, all right, let's see if we have any more questions, and then we get some final thoughts here. Okay, that's it, Pat. So one more thing I want to just touch on is, before we go, Justice Sotomayor's concurrence, because I think she made 2 points. We already kind of touched on one, but she wrote separately just to make these observations, which is always kind of just the little pick me up you need after reading an Alito opinion, which is, she joined this opinion and she's writing separately to observe that the opinion does not depart from the standard that we just mentioned regarding third-party harms. That is part of the analysis. And if the undue hardship only involves burdens and hardship on other employees or coworkers, then that is sufficient. So she wrote separately to make that observation, and she wrote separately to say that the court, wisely did not overrule Hardison or disrupt its legacy, because the court really is not acting at the apex of its power here, because all they're doing is interpreting a statute. And it's important. We talked about this a lot after we were analyzing the oral arguments, because this featured pretty prominently in the oral arguments, especially by Justice Kagan, which is the court has the authority to, has peak authority to rule on constitutional questions. But their authority is weaker where all they're doing is interpreting statutes that Congress passed. And in this case, the language at issue has been in place and has been interpreted by the courts, like we said, since the 70s. And Congress has had many decades and many invitations, right? Actual legislation has been introduced to amend Title VII, this part of Title VII. And they've amended other parts of Title VII, but not this part of Title VII. So the point being made by Justice Sotomayor is Congress has the power to change this interpretation. This is all a congressional statute, Title VII, the Civil Rights Act. This is for Congress to do. It's not for religious right organizations to come to this court and try to get policy made, from policy made that they can't get from Congress. And so I think that was an important point to kind of draw forward again, because it featured in oral arguments, not so much in the majority opinion, but it's worth not losing sight that this is a matter of legislation, and Congress can change any of this at any point. And it's not for this super conservative, corrupt, like illegally packed court to just like give its own interpretation of what it thinks the standard should be for Title VII. So that's Sotomayor's.
She's my favorite justice.
Concurrence.
I always say this. Like she's. It's easy to tell
Totally.
where I'll skip ahead to read her concurrence before I read the opinion because I'm like, okay, now she's summarizing what happens above, and so I think that's very helpful to do in this case as well.
Yes, sets a tone. Okay, well, I think that's going to conclude this special episode of Ask an Atheist. Thank you so much for watching and for joining us. We'll be back at our regular time next Wednesday at noon Central, and in that episode, we're going to be examining the remaining case on the docket, and that's 303 Creative. It is coming down tomorrow, the last day of the Supreme Court term. It's about a web developer that doesn't want to work for gay people. So check it out. And
check out Free Thought Radio, FFRF's weekly radio show and podcast. This week, Dan Barker and Annie Laurie Gaylor speak to Jeff Abbott, talking about narco-pastors and right-wing evangelicals affecting Latin American politics and policies. To find out where to hear Free Thought Radio, visit ffrf.org/radio. And if you want more state-church separation talk from the perspective of women attorneys in the secular movement, like me, check out the We Dissent podcast. In our latest episode, we discussed the Groff v. DeJoy case before the decision came down. So you can listen to all of our predictions and takes on the case. And you can hear an update in that feed soon. Find us wherever you get podcasts. Check us out on Facebook and Twitter or at we-dissent.org. And if you want more information about FFRF, check out our website at ffrf.org. We will see you next time on FFRF's Ask an Atheist.